Police stop alert. 3 magic phrases to protect your visa and green card the moment the siren sounds behind you. Your body already knows something is wrong. A routine drive home. A familiar road. And then the unmistakable flash of red and blue filling the inside of your car like a warning signal you were never trained to decode. A sharp tap on the glass. A blinding flashlight pointed directly at your face. An officer leaning into your window with questions that sound polite but are designed with purpose. This moment didn't build over months of surveillance. It built in under 3 minutes. 3 minutes that could end your visa. 3 minutes that could trigger a federal hold. 3 minutes that could place you inside a removal proceeding before the sun goes down. One sentence spoken in the wrong direction, and everything you've built in this country begins to unravel. What happened to the man in this story crossed a line that immigration enforcement had been watching for quietly, patiently, and with full intention. And when that line broke, the system did not slow down. It responded with speed, precision, and a level of coordination most immigrants never see until it's standing at their window. Most people panic in this moment. They talk. They explain. They try to seem cooperative by saying things they never should have said. They walk straight into the trap. But today, you're going to learn 3 phrases, just 3, that can protect your visa, protect your green card, and protect everything attached to your name in this country. For years now, there had been signals, not from official enforcement bulletins, not from formal policy announcements, just quiet signals, that federal immigration priorities were being pushed deeper into places most immigrants considered safe. Not just border checkpoints, not just airports, ordinary roads. Ordinary stops. Ordinary Tuesday afternoons. Local law enforcement had been expanding its role, yes, but also deepening its coordination with federal immigration databases in ways that were not announced and not publicized. Their activity followed a pattern, a quiet expansion, a period of testing, almost a normalization. But what began alarming immigration attorneys and civil rights organizations this year was that the quiet expansion suddenly became something else entirely. It became infrastructure. Legal advocates who monitor enforcement trends recognize the warning indicators. The sharp increase in ICE detainer requests sent through local law enforcement channels. The expansion of information sharing agreements between police departments and federal immigration databases. The rollout of updated fingerprinting and identification protocols at routine traffic stops in certain jurisdictions, and the sudden silence from enforcement agencies that had previously been communicating publicly about the scope of their work. When the people running the system stop explaining what the system is doing, something has already changed. Early this year, immigration legal networks and civil liberties organizations began documenting what they described as a systematic shift in traffic enforcement tactics, including the use of minor vehicle violations as a documented entry point into immigration status investigations, not seen at this scale in well over a decade. These are tactics enforcement agencies only deploy when pursuing something specific. A broad interior enforcement expansion targeting communities with high concentrations of non-citizen residents. A strategy of building immigration cases not through targeted warrants, but through accumulated data from daily encounters. Or a coordinated effort to use the ordinary moments of immigrant life, a commute, a school run, a grocery trip, as the front lines of immigration enforcement. Observers in the legal community weren't certain which of these was the primary driver, or whether all 3 were operating simultaneously. But one thing was beyond dispute. The strategy around traffic stops had shifted in a way that made every single immigrant driver more vulnerable than they were 12 months ago. And when enforcement strategy shifts without public explanation, every non-citizen on the road needs to change how they respond to the lights behind them. The alert issued by immigration legal organizations this year was not routine. It was not a general reminder about rights. It was urgent and specific. Attorney after attorney described the new enforcement landscape as layered, deliberately ordinary-looking, and most importantly, exploiting the gap between what immigrants are legally required to say and what they voluntarily choose to say out of habit, fear, or a misguided sense that cooperation will protect them. But legal protection only works if you activate it. Immigrants who know their rights and use them walk away from traffic stops intact. Those who don't, those who fill the silence, answer the extra question, volunteer the unnecessary detail, those are the ones whose stories end differently. Their response in that moment was among the most consequential decisions they ever made, and most of them didn't even realize they were making a decision at all. Here is what legal experts and immigration attorneys confirmed through case documentation, public records, and years of direct representation. Officers conducting pretextual traffic stops initiated for minor infractions, but pursued for deeper purposes, are targeting drivers based on a range of signals. They target communities flagged in shared enforcement databases. They target individuals whose names or vehicles appear in prior law enforcement encounters. They target passengers and drivers connected to addresses that have already been the subject of immigration-related activity. The stop itself is not the threat. The conversation that follows is, a minor traffic violation alone is rarely sufficient to initiate an immigration enforcement action, but a minor traffic violation combined with a self-incriminating statement, a single sentence that reveals status or complicates it, or raises a question that a federal database then answers, that combination is the pipeline. That is what has ended legal residency for people who had done nothing wrong except speak when they didn't have to. So here are the 3 phrases. 3 sentences that immigration attorneys across the country recommend memorizing before you ever get behind the wheel again. Not 3 complicated legal arguments. Not 3 aggressive confrontations. 3 calm, simple, constitutionally protected statements that close the pipeline before it opens. The first phrase is this: I'm exercising my right to remain silent. That is it. 5 words. No elaboration. No apology. When an officer asks where you're going, where you're coming from, whether you live nearby, where you were born, or whether you're a citizen, this is your answer. You do not say, I'd rather not say. You do not say, I don't feel comfortable answering that. You do not say, I don't speak English well, when you do. You say, I'm exercising my right to remain silent. This phrase is legally recognized. It is constitutionally protected. It signals to any officer and to any court that later reviews this encounter that you knew your rights and you used them. It cannot be used against you. Silence cannot be used as evidence of guilt in this context. But every word you add after unnecessary silence can be used in ways you will not be able to undo. The second phrase is this: I do not consent to any searches. This matters more than most immigrants realize. An officer may ask to look in your glove compartment, may ask if they can look in the back seat, may ask you to step out while a colleague looks through the vehicle. Some of these requests are legal, some are not. You are not always in a position to know the difference in real time. What you are always in a position to do is withhold consent. If an officer has legal authority to search your vehicle, your consent is not required. They will search regardless. But if they are asking your permission, it means they do not yet have that legal authority. And if you say yes, if you say sure, go ahead because you want to appear cooperative, because you think you have nothing to hide, because you assume politeness will protect you, you have just handed them authority they did not legally possess. You say, I do not consent to any searches. Calmly, without hostility, without moving from your seat unless instructed. This phrase does not guarantee nothing will happen, but it creates a legal record that your rights were asserted and that any evidence gathered without proper authority was gathered over your explicit objection. That record matters later. It can be the difference between a case that moves forward and a case that gets thrown out. The third phrase is this: I want to speak to an immigration attorney. Not just any attorney, an immigration attorney. This phrase does 2 things simultaneously. First, it invokes your right to counsel, a right that applies to every person on American soil regardless of immigration status. Second, it signals specifically that the topic of immigration is in the picture and that you understand the stakes of this conversation in a way that an unprepared person typically would not. Officers who are conducting ordinary traffic stops do not need you to invoke an immigration attorney. But officers who are fishing for immigration information, who are operating inside the pipeline described earlier, will hear this phrase and understand that the next step in the encounter just became more complicated for them. You are not required to say this immediately, But the moment a conversation begins to shift, the moment questions move from license and registration toward identity, nationality, birthplace, documentation, or status, this is the phrase you use. I want to speak to an immigration attorney. And then you say nothing else. Now let's talk about the moment these phrases will feel the hardest to use. Because there will be a moment like that. An officer who appears friendly, who seems like they're just doing their job, who says something like, "Look, I'm not trying to cause you trouble. I just need to verify a couple of things." It'll only take a second. That is a pressure technique. It is designed to make you feel like invoking your rights is an overreaction, like it creates a problem where there wasn't one. Like the reasonable thing to do is just answer the question. This feeling is the trap. Cooperating with a routine traffic stop means providing your license, registration, and insurance. It does not mean answering questions about your nationality. It does not mean explaining your visa history. It does not mean describing what country you came from or how long you've been here or what your current application status is. You do not owe that information to anyone at a traffic stop. And any officer who tells you otherwise is either mistaken about the law or deliberately misrepresenting it. Stay calm. Stay steady. Repeat your phrases. I'm exercising my right to remain silent. I do not consent to any searches. I want to speak to an immigration attorney. Let's talk specifically about green card holders, lawful permanent residents, because this is where a dangerous assumption lives. Many green card holders believe that their status protects them completely in a traffic stop situation. It does not. Green card holders can be placed in removal proceedings. If your green card carries conditions that were never formally removed through the I-751 process for marriage-based cards, for example, your permanent residence is technically conditional. If you have any criminal history, including misdemeanor convictions that you may consider minor, an old DUI, a disorderly conduct charge from years ago, those convictions can be raised in a removal context. If your card is expired and your renewal is pending, an officer who doesn't understand the grace period around renewals may treat your status as more uncertain than it legally is. None of these situations means you are going to be deported, but all of them mean that a traffic stop conversation that goes the wrong direction can open a door that leads to a proceeding you were not expecting and are not prepared for. Green card holders need these three phrases just as much as anyone else. The protection of lawful status is real, but it is not unconditional, and it is not self-activating. You have to claim it. Let's also talk about student visa holders F1 and J1 visa holders, because there is a specific vulnerability in your situation that is not widely discussed. If you are on a student visa and you have any violation on your record, even something that resulted in no conviction, even something that was dismissed, it may have implications for your status depending on how it was handled and documented. More importantly, if you have been working off campus without authorization, or if your enrollment status has lapsed for any reason, your F1 status may be more complicated than your I-20 document alone suggests. A traffic stop conversation that begins as a routine check and ends with you explaining your situation in detail can create a record that is later reviewed by USCIS or an immigration judge. You do not need to create that record. Student visa holders especially must resist the urge to over-explain. You are intelligent. You are articulate. You are accustomed to being asked to demonstrate your knowledge and respond thoroughly. A traffic stop is not an oral exam. The three phrases are your entire script. Nothing more. One last scenario that immigration attorneys raise repeatedly. What happens after the stop is over? You've received your documents back. You've been told you're free to go. And as you reach for the gear shift, the officer leans back in and says, "Actually, one more thing. This is called a consensual encounter. Once a traffic stop has formally ended, the legal framework changes. You are no longer detained. The encounter is technically voluntary. And in that moment of relief, in that exhale after the tension, people say things they would not have said 5 minutes earlier. Oh, I just wanted to let you know I have a work permit. I'm waiting on my green card renewal. I was actually born in country, but I've been here since I was a kid." All of that information, given voluntarily after the stop ends, is real. It is documentable. It can be used. When a stop ends, you say, "I'd like to leave now." And you leave. You do not linger. You do not offer a final friendly detail. You drive away. The conversation is over the moment they say you're free. As enforcement operations continue to expand in scope and reach, more stories will emerge of immigrants, documented and undocumented, green card holders and visa holders, who lost their status in a moment that began with a broken taillight and ended with a sentence they never needed to say. But one thing is already clear. Knowing these 3 phrases does not make you suspicious. It does not make you a criminal. It does not make you uncooperative or dangerous or disloyal. It makes you smart. It means you understand the legal system you are living inside. It means you are protecting your status, your family, and your future with the most powerful tool available to you, your own silence, used with confidence and purpose. Write these phrases down. Say them out loud until they feel natural. Share this video with every immigrant family you know. It might save a visa. It might save a green card. It might keep a family together on a night that could have gone a very different direction. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of enforcement unfolds.